हेलो।
हाँ
हाँ कमल जी।
हाँ सर।
हाँ सर, जय जिनेन्द्र सर।
जय जिनेन्द्र।
हाँ लोग जुड़ा को नहीं क्या भी।
ओमरम
ओमरम
क्या भाई, और कौन कौन ज्वाइन हो गया के?
हो रहा है अभी 2-5 मिनट आगे। काकरा जी ज्वाइन हो गया, नारायण जैन जी ज्वाइन हो गया।
बहुत बढ़िया। तानिशा भी होगी ज्वाइन।
हाँ
तानिशा ने एक बार अनम्यूट करया।
हेलो
तानिशा,
हाँ
आर यू रेडी?
या हाँ
ओके। ओमरम
उमरम
बताइए आपको।
1.5 लाख आया है।
नहीं निकला 1.5 लाख रुपया। 2,30,500 रुपया जो है आपका ये है करीब।
हमारे राष्ट्रीय अध्यक्ष श्री विनोद जी कोटेचा जी जुड़ गए हैं, उनका भी स्वागत है। आलोक जी आलोक जी
साहब नारेबाजी
कार्यक्रम की शुरुआत करें।
हाँ आलोक जी।
हाँ,
19 आदमी आए अभी
वंदे
तक।
गुरुवरम वंदे सतीवरम। हमारे
5 मिनट बाद में
TPF
शुरू कर रहे हैं। 5 मिनट
5
बाद
मिनट
में शुरू करेंगे आगे।
दो लाख 30,700 ये कौन सी का पैसा आया ये हमको बताइए। और ये पैसा कैसी कहाँ गया 1.5 लाख रुपया।
नारायण जी ओम राम जय जिनेन्द्र।
हाँ जय जिनेन्द्र सर।
हाँ नारायण जी जय जिनेन्द्र।
जय जिनेन्द्र सर।
सुशील जी जय जिनेन्द्र। कोटेचा जी जय जिनेन्द्र साहब।
जय जिनेन्द्र सर।
सुशील जी ओम राम। कोटेजा जी ओम राम। कमल जी आप शुरुआत कर सकते हैं।
हाँ 1 बजे से चले आइएगा अभी
कमल जी।
आए 4 घंटा लगेगा। हाँ अब इनका कितना टाइम लगेगा हम नहीं जानता है ना जो तो इनका फाइल है। आ जाइए ना।
नारेवा जी है क्या?
अरेवा जी
वो स्क्रीन शेयर कर दीजिएगा मेरे साथ पीपीटी के लिए। कौन कंट्रोल कर रहा है? स्क्रीन शेयर कर दीजिएगा, एडमिन को बोलिए।
वो कौन है?
स्क्रीन शेयर करिएगा मेरे साथ पीपीटी लगाने के लिए।
अरेवा जी अरेवा जी।
हाँ कमल जी हैं।
हाँ, तो कमल जी को आग्रह करें कि स्क्रीन शेयर करने का दे दें। नारायण जी का स्क्रीन शेयर का दे दें, ऑन कर
दे
दें।
दिया है, दे दिया है।
ठीक है,
हाँ
थैंक
तो
यू।
अब चालू किया जाए कमल जी। अपने निर्मल जी भी जुड़ गए हैं, सुशील जी भी जुड़ गए हैं तो
वंदे गुरुवरम वंदे सतीवरम। तेरापंथ प्रोफेशनल फोरम के मुख्य पर्यवेक्षक उन्हीं रजनीश मुनि के चरणों में वंदन। यहाँ विराजित स्वर्ण रेखा जी एवं सहवर्ती साध्वियों के चरणों में शत शत वंदन। आज हम सब यहाँ उपस्थित हुए हैं इनकम टैक्स संबंधी संगोष्ठी में भाग लेने के लिए। संगोष्ठी का विषय है सर्वे सर्च केसेस एंड रेलेवेंस ऑफ इलेक्ट्रॉनिक एविडेंस। यह संगोष्ठी तेरापंथ प्रोफेशनल फोरम साउथ कलकत्ता, तेरापंथ प्रोफेशनल फोरम कोलकाता एवं लीगल रिलीफ सोसाइटी के संयुक्त तत्वाधान में हो रही है। और हमारे वक्ता हैं चिर परिचित सुविख्यात एडवोकेट नारायण जी जैन। हम कार्यक्रम की शुरुआत करेंगे नमस्कार महामंत्र से। नमो अरिहंताणं, नमो सिद्धाणं, नमो आयर्याणं, नमो उमज्झायाणं, नमो लोये सब्बसाहूणं,
पंचनमोकारो सभ्य पावपनाशनो
मंगलाणं च सभ्य
सर्वे
सिंह
सिंह
पढ़मं हवै मंगलम पढ़मं हवै मंगलम। अब मैं निवेदन करूंगा तेरापंथ प्रोफेशनल फोरम साउथ कलकत्ता के अध्यक्ष श्रीमान धर्मचंद जी धाड़ेवा जी से कि वो अपना वक्तव्य दे।
बहुत बहुत धन्यवाद आलोक जी। आवाज आ रही है?
हाँ
आ रही है, एकदम आ रही है।
बहुत बहुत धन्यवाद आलोक जी, आपने मुझे समय दिया। तो आराध्य के श्री चरणों में बंदन। हैदराबाद में विराजित महातपस्वी महाज्ञानी आचार्य श्री महाशर्मन जी के चरणों में बंदन। हमारे टीपीएफ के पर्यवेक्षक डॉक्टर रजनीश कुमार जी के चरणों में बंदन। दक्षिण हावड़ा में विराजित साध्वी श्री जी शरण रेखा जी के चरणों में बंदन। आज का ये जूम के माध्यम से टीपीएफ साउथ कलकत्ता और कलकत्ता ब्रांच द्वारा आयोजित आयकर संबंधी संगोष्ठी में आप सभी जुड़े हैं। आप सबका मैं स्वागत करता हूं। हमें खुशी है कि आज हमारे बीच हमारे साथ में जुड़े हैं हमारे राष्ट्रीय अध्यक्ष श्री निर्मल जी कोटेचा और राष्ट्रीय महामंत्री श्री सुशील जी चौडिया। मैं उनका तहे दिल से स्वागत करता हूं। और मैं स्वागत करता हूं हमारे एडवोकेट नारायण जी जैन, जो कलकत्ता के बहुत ही सुप्रसिद्ध और जाने माने एक छवि है। उन्होंने आज हमारा समय निकालकर हमारे जो कमल जी जैन का रिक्वेस्ट उन्होंने माना और आज हमको समय देके आज इस गोष्ठी में जुड़े और एक मुख्य प्रवक्ता की भूमिका निभाएंगे। मैं उनका स्वागत करता हूं। मैं स्वागत करता हूं हमारे काकरा जी, जो वापिस दूसरी बार भी उन्होंने हमको टीपीएफ को समय दिया। उनका मैं बहुत बहुत स्वागत करता हूं। और आज जूम में सभी जुड़े हुए जो हमारे सदस्यगण हैं, अतिथिगण हैं और सामान्य संस्थाओं के सभी पदाधिकारियों का मैं नाम नहीं ले पाऊंगा, सब जुड़े हुए हैं। हमारे जो उपाध्यक्ष है श्री जतनलाल जी बल्डिया, वो भी जुड़े हुए हैं। मैं सभी का स्वागत करता हूं। और मुझे विश्वास है जो नारायण जैन जी जो इतने अच्छे जो सलाहकार है, हमको ये सर्च सीजर इसके केस के बारे में हमको पूर्ण जानकारी देंगे, हमको पूरा बात बताएंगे। इसके साथ ही मैं ज्यादा समय नहीं लूंगा। मैं अनुरोध करूंगा हमारे राष्ट्रीय अध्यक्ष श्री निर्मल जी कोटेचा जी से कि वो हमको आगे इसके बारे में बताएं और हम लोगों को आशीर्वाद दें। श्री निर्मल जी कोटेचा जी।
धर्म संघ के एकादशम अधिष्ठाता आचार्य श्री महाश्रमण जी के चरणों में सभक्ति वंदन। जूम मीटिंग में उपस्थित हमारे साउथ कोलकाता के अध्यक्ष धर्मचंद जी भाई साहब, मंत्री आलोक जी, आज के हमारे मुख्य वक्ता एडवोकेट नारायण जी, एडवोकेट काकड़ा जी, सभी को सादर नमस्कार। बड़ी प्रसन्नता है कि तेरापंथ प्रोफेशनल फोरम हमारी कलकत्ता की शाखाएं निरंतर एक्टिव है, सक्रिय है और लगभग प्रति रविवार को नए से नए एक एक कार्यक्रम लेकर के आपके समक्ष उपस्थित हो रही है। मैं हमारी कलकत्ता की ब्रांचेज और अभी आज कि हमारे जो ये समसामयिक विषय है इनकम टैक्स का सर्च सर्वे सीजर, इनके ऊपर में आपने एक यह कार्यक्रम आयोजित किया। आप सभी जानते हैं तेरापंथ प्रोफेशनल फोरम का जो मुख्य उद्देश्य है वह यही है कि नॉलेज शेयरिंग, और आज इसी दिशा में यह कार्यक्रम, ये जो तेरापंथ प्रोफेशनल फोरम का ये जो कार्यकाल है अपनी संपन्नता पर है। हमारे जितने भी सदस्य और प्रोफेशनल भाई यहाँ उपस्थित है, मैं सभी से निवेदन करना चाहूंगा कि आप 2 तारीख को 2 अक्टूबर को हमारी एजीएम है टीपीएफ की और 3 और 4 को नेशनल कॉन्फ्रेंस के सभी सूचनाएं आपके पास पहुंच चुकी हैं। आप निश्चित रूप से वर्चुअली, चूंकि अभी जो समय चल रहा है उसमें यही संभव है, तो वर्चुअली आप सभी जुड़ें और हमारे इस 3 दिन के कार्यक्रमों का पूरा उसमें जुड़कर हमारा उत्साह बढ़ाएं। इन्हीं भावनाओं के साथ पुनः हमारी 13 पंथ प्रोफेशनल फोरम कोलकाता, साउथ कोलकाता दोनों हमारी ब्रांचेस को बहुत बहुत धन्यवाद, साधुवाद। ओम अर्हम।
ओम। आलोक जी।
अब मैं निवेदन करूंगा हमारे श्री आर.डी. काकरा जी से कि वो विषय की जानकारी दें। काकरा जी, आपकी आवाज नहीं आ रही है। आप अनम्यूट करें अपने आप को।
Now I am audible?
Yes, now you are.
आचार्य श्री के चरणों में नमस्कार करते हुए आज पुनः आपसे मिलने की जो मिलकर मैं बहुत आनंदित हूँ। तेरा पंथ के राष्ट्रीय अध्यक्ष और अन्य सभाओं संस्थाओं के जो भी आज इस प्रोग्राम में वेबिनार के अंदर उपस्थित है, सबको नमस्कार, जय जिनेंद्र। आज का विषय है सर्वे, सर्च एंड सीजर, डिटेक्शन। ये इतना बड़ा विषय है कि गागर को सागर में समा लेने की जो क्षमता रखता है वो जेएनजी रखते हैं। तो अपने वक्तव्यों को तो हम बहुत संक्षिप्त में कहेंगे, लेकिन ये बहुत आनंद का विषय है कि 13 अगस्त को हमारे माननीय प्रधानमंत्री महोदय ने जो एक टैक्स चार्टर, ट्रांसपेरेंट टैक्सेशन एंड ऑनरिंग द ऑनेस्ट, जो बहुत प्रतीक्षित सब्जेक्ट था, उसको आरंभ किया और डायरेक्ट टैक्स रिजीम के अंदर में अभूतपूर्व टैक्स रिफॉर्म की शुरुआत की। यह वो आप भी सब महसूस करते होंगे कि फेसलेस असेसमेंट और फेसलेस अपील जो चीजें आरंभ हुई है बहुत सुंदर है, उसका स्वागत है, लेकिन उस स्वागत के साथ साथ हमारे ऊपर, हम जो टैक्स पेयर्स हैं, उसकी भी बहुत रिस्पॉन्सिबिलिटी आ जाती है। आज के सब्जेक्ट की शुरुआत सर्वे से है। आप सभी ने अनुभव किया है कि विगत के अंदर में सर्वे जब भी होता है, सर्च जहाँ कहीं भी होती है, डिपार्टमेंट की हाई हैंडनेस बहुत ज्यादा रहती है। टैक्स पेयर चार्टर जो जिसकी शुरुआत जो पहले केवल एक कोने में पड़ा रहता था, फेसलेस असेसमेंट और फेसलेस अपील से ये हमें विश्वास हो गया कि टैक्स पेयर चार्टर के ऊपर में भी पूरा काम होगा और जो भी ग्रीवांसेस रहेगी टैक्स पेयर की वो पूरी सुनी जाएगी। टैक्स पेयर चार्टर के अंदर में 14 बातें तो गवर्नमेंट ने अपने लिए रखी है और केवल 6 चीजें टैक्स पेयर से संबंधित है जो उनसे आशा की जाती है। प्रथम बार अकाउंटेबिलिटी की बातें आई है कि आपके साथ कोई भी अन्याय होता है और कोई भी गलत बातें होती है तो आप बेखौफ जो ऑर्गेनाइजेशन है, ग्रीवांसेज है, वो अपनी कहिए। हाई हैंडनेस की तो ऐसी बात है, सर्वे के अंदर में जो भी आते हैं आपके बिजनेस प्रीमिसेस के अंदर में सबसे पहले तो जो आपका वीडियो चलता रहता है या जो सिक्योरिटी के लिए आपने लगा रखा है, सबसे पहले तो वो बंद करते हैं। अब आप खुले रूप से उन्हें कह सकते हैं कि आप इस थर्ड आई को बंद न करें। उसके बाद में भी वो करता है तो बोले आप कर दीजिए। तो बहुत सी चीजें जो है वो धीरे धीरे डिसिप्लिन में आ रही है। सर्वप्रथम हमने आज के प्रोग्राम को की शुरुआती प्रार्थना से की। प्रार्थना आदमी को ये एक डिसिप्लिन है। तो टैक्स पेयर चार्टर और डायरेक्ट टैक्स रिफॉर्म जो है ये एक डिसिप्लिन के अंदर में अब आ रहा है और इसके साथ ही इस डिसिप्लिन के साथ में सरकार के साथ हम जितना सहयोग करेंगे वो कीजिए। 6 बातें जो आपसे मांगी जा रही है, आपसे गवर्नमेंट आशा करती है, वो ये कि आप ऑनेस्ट रूप से अपने खाते रखें, अपना कंप्लायंस जो टैक्स का है उसको ध्यान में रखें। आपके रिप्रेजेंटेटिव जो हैं, हम एडवोकेट्स या चार्टर्ड अकाउंटेंट या जो कुछ भी है, वो क्या करते हैं उस पर भी आप ध्यान रखिए, ताकि आपको ज्यादा समय नहीं मिलेगा तो आपको अपनी चुस्ती ही काम आएगी। भाई धीरे नोटबंदी और सब करते हुए ये जो मानस जो बना हुआ था वो बहुतों का अब ये हो गया कि हमें हेरा फेरी की वाली बातें नहीं है, एडजस्टमेंट की बातें नहीं है, ये प्राय मन सभी का तैयार हो चुका है। अब ये सेकेंड स्टेज जो है जिसके अंदर में कंप्लायंस की बातें हैं, आप कंप्लायंस के हिसाब से आपसे जो 6 चीजें सीखी वो बहुत यही भी कि आप टैक्स कंप्लायंस आपका रिटर्न का है, आपके टैक्स का है, उस हिसाब से करें।
ठीक है,
मैंने तो अपनी शुरुआती
देख लिया, ठीक है।
44 ईयर्स बैक अपने शुरुआती जीवन की सर्वे और सर्च एंड सीजर से की, तो ये दौर तो मैं पूरी तौर से देख चुका हूं और जानता हूं कि इसके अंदर में कितना बड़ा रिफॉर्म आ गया है और उस रिफॉर्म के अंदर में हमें सहयोग देना है और हमसे बहुत आशा कम की जा रही है कि आप कंप्लायंस रह के करें, तो कंप्लायंस के लिए कोई असुविधा नहीं है। और टाइमली जो अपने टीडीएस का हमारा का कंप्लायंस है या रिटर्न का कंप्लायंस है, वो कंप्लायंस हमें करें। उसी प्रकार सर्च एंड सीजर के अंदर में भी अमूर्त परिवर्तन ये कर दिया गया सर्वे के अंदर में। पहले तो सर्वे इनकम टैक्स ऑफिसर से जो भी वो आ जाता था और हर एक कोई को, अब केवल इन्वेस्टिगेशन विंग और टीडीएस विंग को अधिकृत किया गया है कि वही सर्वे कर सकते हैं। इसलिए गवर्नमेंट अपने ऊपर में भी बहुत जगह पर छूट दे रही है, चीज दे रही है। वो जानती है टैक्स कलेक्शन पहले से बहुत कुछ कम हो गया है, इस चीज को गवर्नमेंट जानती है, लेकिन फिर भी सतत प्रयास उसका है कि टैक्स रिफॉर्म हो। आज की मीटिंग के साथ साथ ही हमारे 3 तारीख को भी हमारी एक ऑल इंडिया मीटिंग है जिसके अंदर में टैक्स कल्चर और टैक्स रिफॉर्म के विषय में बातें होगी और उसके अंदर में चीफ जस्टिस है और नारायण जी भी उसके अंदर में एडवोकेट है, मैं भी हूँ। तो ये जो दौर चल रहा है उसमें हमें सहयोग देना चाहिए और जो नए परिवर्तन हो गए हैं उस परिवर्तन के साथ साथ चलना चाहिए, ये सबसे बड़ी जरूरी है। और नारायण जी इसके बाद में आपको सर्च एंड सीजर और उसके जो अलग प्रावधान है उसके विषय में बताएंगे। मैं ज्यादा समय नहीं लेते हुए अब नारायण जी से अनुरोध करूंगा कि वो अपना वक्तव्य आरंभ करें।
नहीं, एक बार बहुत बहुत धन्यवाद काकड़ा जी, आपने बहुत अच्छी तरह से सबको समझाया। आप तो टैक्स के गुरु हैं और हमारे कमल जी जैन जो बहुत ये जो कार्यक्रम है उन्हीं के सहयोग से ही आज ये कार्यक्रम रखा है, बहुत बहुत धन्यवाद। हमारे साथ हमारे विशिष्ट और बहुत ही माननीय जो टीपीएफ के हमारे सदस्य है श्री कैलाश जी गोयल, वो भी हमारे साथ जुड़े हैं, हम उनका स्वागत करते हैं और मैं अनुरोध करूंगा आलोक जी से कि आगे का कार्यक्रम चालू करें।
इस कार्यक्रम को अब आगे बढ़ाते हुए अब मैं निवेदन करूंगा सुश्री तनिषा कोचर से कि वो हमारे सुप्रसिद्ध वक्ता का परिचय दे।
Vande Guruvaram, Vande Sativaram. Good morning, everyone. It is a great pleasure for me to introduce our speaker today, who is going to talk to us about survey, search cases, and the relevance of electronic evidence. This is a subject in which all of us should be deeply interested because of its rising importance in the current scenarios. Our speaker, Narayan Ji Jain, has spent his entire career in advising about matters related to taxation. After completing his LLB and LLM, he is practicing as an advocate since 1982. He is the founder of Direct Taxes Professional Association and has served as its president in 1986 and 87. He has acted as an arbitrator in many cases referred to him by the Honorable Calcutta High Court. He has also been a member of the Arbitral Tribunal. He is a regular contributor of articles in various magazines, newspapers, and other dailies. He is an award-winning person. The Ministry of Finance of India has conferred upon Mr. Jain and his co-author, Mr. Dilip Loyal Khate, Direct Taxes Literature Award for the year 1994-95 for his famous book Kaise Suljhaएं Aikar Samasyaएं. Presently, he has served as the National Co-Chairman of Direct Taxes Representation Committee of All India Federation of Tax Practitioners for 2019. He has served AIFTP in various capacities. Aside from his talent and advocacies, Mr. Jain is also a prestigious author for famous taxation books and is also the coordinating editor of the famous magazine Taxman. He is a visiting faculty at IIM Kolkata, National University of Judicial Sciences, ICAI, ICSI, ICWAI, and various other institutions. He has been appointed as the member of Board of Studies in Faculty of Law of Mahatma Gandhi Kashi Vidyapat University, Varanasi. Also, he is actively associated with a number of NGOs, including Rotary Club of Calcutta. On a final note, we are grateful for his presence among us today. Without further delay, please join me in welcoming Mr. Narayan Ji Jain. Welcome, sir.
थैंक यू तानिशा। अब मैं आग्रह करूंगा श्री नारायण जी जैन से कि वो अपना वक्तव्य रखें।
धन्यवाद। Give me a minute, please.
स्क्रीन शेयर हो गया ना आपका?
देख रहा हूँ, हो गया होगा। साथियों, can we begin?
हाँ,
Can you hear me?
हाँ, yes sir.
Yes, yes.
Start.
Yes, you can.
हाँ,
Let us start.
ओके। हमारे 13 पंथ प्रोफेशनल फोरम और लीगल रिलीफ सोसाइटी के संयुक्त कार्यक्रम में मुझे एक बार फिर आप लोग के बीच में मेरे विचार रखने में खुशी है। और 13 पंथ प्रोफेशनल फोरम में मैं कभी भी आता हूँ तो मैं समझता हूँ घर में ही आ रहा हूँ। हमारे सबसे पहले मैं आराध्य के चरणों में वंदन करता हूँ और आचार्य श्री महाश्रमण जी को भी प्रणाम करता हूँ। हमारी संस्था के श्री निर्मल जी कोटेचा, सुशील जी, श्री कमल जी जैन, आर.डी. काकरा जी, धर्मचंद जी धारेवा, जतनलाल जी बढ़िया भाई जी, जी चोपड़ा, त्रिशा और सभी साथियों। देखिए, ये काकड़ा जी ने भूमिका बताई, फेसलेस असेसमेंट, फेसलेस अपील, कंप्लायंस पर गवर्नमेंट का जोर। तो वो देखिए, टैक्स चोरी का, टैक्स अवॉइडेंस का और गलत तरीके से टैक्स प्लानिंग करने का, गलत तरीके से असेसमेंट पूरा कराने का या अपील फेवरेबल कराने का जमाना चला गया। अब जो है, अब काम खाली नॉलेज बेस और प्रभावशाली रूप से जो आदमी अपना प्रैक्टिस करेगा या अपने केस की पैरवी करेगा, उन्हीं का जमाना अब आ गया है। और देश के लिए तो मैं ये कह सकता हूँ, भी मोदी जी जो भी कर रहे हैं देश के लिए, उनके पास खबर गई थी कि भी बहुत इनकम टैक्स डिपार्टमेंट में अनुचित तरीके से भी काम होता है, इसलिए उन्होंने फेसलेस असेसमेंट और फेसलेस अपील जो है सब लोगों के लिए अनिवार्य करने का नियम किया। और इस देश के लिए हम लोग मोदी जी के साथ ज्वाइन करते हैं। 4 लाइनें बोल के आपके बीच में पहले कि तन समर्पित, मन समर्पित, जीवन का कणन समर्पित, चाहता हूं देश की धरती तुझे कुछ और भी दूं। तो ये भावना हम लोगों की सबकी होनी चाहिए। जो समय चला गया उसको भूल जाके आने वाले समय के लिए हम लोग को सबको तैयार होना है। ठीक है, सब लोग तैयार हैं?
तैयार है एकदम।
अच्छा, चलिए अब अपने विषय पर आते हैं। देखिए, मैंने तो जब प्रैक्टिस शुरू की थी 1976 में, उस टाइम ऐसा सहयोग रहा कि मैंने सर्च एंड सीजर के केस से मेरी प्रैक्टिस शुरू की। इसलिए मेरे को ये जो विषय में और इसी में से जो पीपीटी आप लोग देख पा रहे हैं ना, पावर पॉइंट देख पा रहे हैं?
हाँ हाँ।
नहीं, पावर पॉइंट में आपका प्रेजेंटेशन नहीं आ रहा है नारायण जी।
नहीं आ रहा।
वो आपका
पावर पॉइंट का पहला पेज देख पा रहे हैं?
नहीं
पहला पेज देख पा रहे हैं क्या?
नहीं, ये
तो फाइल के नाम आ रहे हैं सारे।
फाइल आपकी फाइल्स आ रही है सारी।
अभी नहीं आ रहा है
ना।
शेयरिंग स्टॉप करके वापस शेयरिंग करो।
जो आपका फर्स्ट स्क्रीन आया वही आया है या तो?
आपका डेस्कटॉप का स्क्रीन आ रहा है सामने। हाँ, डेस्कटॉप का स्क्रीन आ रहा है सामने।
मैं आपका शेयरिंग स्टॉप कर रहा हूं, फिर से वापस इसको चालू करो।
एक मिनट कर रहे हैं। ये जो ना, ये इसका जो जूम का है,
ये वाला है आपका चालू, और यहाँ पे ये जो शेयर स्क्रीन
ये दो वर्क करूंगा।
एक सेकंड। ये
अभी आ रहा है? पीपीटी आ रहा है?
अभी चालू नहीं हुआ है, अभी होने दीजिए।
पीपीटी मिल रहा है आपको? अभी
लोड हो रहा है।
हाँ,
लोड हो रहा है।
अब पीपीटी आ रहा है कि नहीं?
नहीं, अभी लोड हो रहा है, अभी तक आया नहीं है।
हाँ,
आया नहीं है, लोड हो रहा है।
आ गया।
आ गया।
ठीक है, ओके ओके, सो नाउ वी बिगिन।
या
देखिए आज के 2 सब्जेक्ट अपने इसमें है। पहला एडमिशन एंड रिट्रैक्शन इन सर्वे एंड सर्च केसेस और दूसरा रिलेवेंस ऑफ डिजिटल एविडेंस। तो पहला जो विषय है एडमिशन एंड रिट्रैक्शन इन सर्वे एंड सर्च केसेस, तो ये हम लोग पहले डील करेंगे, बाद में समय रहेगा तो हम लोग डिजिटल एविडेंस में जाएंगे। और ये देखिए सर्च के जो जनरल प्रोविजन है, सर्वे के जनरल प्रोविजन है, उसकी हम व्याख्या नहीं करेंगे। हम लोग ज्यादा जोर देंगे कि सर्वे सर्च में जो ऑफिसर्स आते हैं और जो स्टेटमेंट रिकॉर्ड करते हैं उसमें एडमिशन करवा लेते हैं एक्स्ट्रा इनकम का, या बाद में जब कितना करोड़ रुपया कर दिया फिर बाद में आदमी सोचता है मैंने गलत कर दिया, अपना एडवोकेट चार्टर्ड अकाउंटेंट के पास जाता है, तो फिर वो देखते हैं कि जहाँ पर कोई नाजायज हुआ तो रिट्रैक्शन करने का उसको सुझाव देते हैं। तो ये किस ढंग से इस प्रक्रिया को हम लोग को पूरा करना चाहिए, और रिट्रैक्शन एडमिशन एक बार कर लिया उसके बाद में हम कहेंगे कि नहीं ये हमने तो नहीं किया या हमने गलत किया, तो ये कह देना ही सफिशिएंट नहीं है, उसको प्रूफ। ये बातें जरा हम कुछ कोर्ट केसेस को भी रेफर करेंगे, क्योंकि देखिए बाकी लोग जो भी है पार्टिसिपेंट उनको आप म्यूट कर दीजिए ताकि और कोई आदमी नहीं बोले, बाकी लोगों को सबको म्यूट कर दीजिए। तो ऑथराइज्ड ऑफिसर में ड्यूरिंग द कोर्स ऑफ द सर्च और सीजर एग्जामिन ऑन ऑथ। देखिए एक स्टेटमेंट होता है वो ऑथ पे नहीं होता है जैसे सर्वे में होता है, और दूसरा स्टेटमेंट होता है ऑन ऑथ। जो लॉ में जो एविडेंस की वैल्यू है, जो स्टेटमेंट ऑन ऑथ रिकॉर्ड किया जाता है उसकी वैल्यू है। तो ऑथराइज्ड ऑफिसर माने जो लोग रेड करने जाते हैं वो लोग ऑथराइज्ड ऑफिसर कहलाते हैं। They may examine on oath any person who is found to be in possession or control of any books of account, documents, money, bullion, jewelry, or other valuable article or thing. And then the second limb of this section is that and any statement made by such person during such examination may thereafter be used in evidence in any proceeding under the Income Tax Act. ये प्रावधान भी 134 में। इसके बाद में सरकार ने एक एक्सप्लेनेशन ऐड किया। एक्सप्लेनेशन में कहा कि द एग्जामिनेशन ऑफ एनी पर्सन अंडर दिस सब सेक्शन मीन्स 132(4) may be not merely in respect of any books of account, other documents or assets found as a result of the search, but also in respect of all matters relevant for the purposes of any investigation connected with any proceeding under the Income Tax Act. माने वहां पर जो सर्च के दौरान बुक्स ऑफ अकाउंट या जो असेट मिली, खाली उससे संबंधित ही स्टेटमेंट नहीं, बल्कि वो जो स्टेटमेंट है वो इनकम टैक्स के अंतर्गत कोई भी इन्वेस्टिगेशन या कोई भी कार्रवाई के लिए डिपार्टमेंट यूज कर सकता है। अब एक और इससे संबंधित एक धारा है सेक्शन 292C। 292C कहता प्रिजम्पशन। तो प्रिजम्पशन क्या है, ये देखिए सेक्शन 292C कहता है ये फाइनेंस एक्ट 2007 में लाया गया, किंतु लाया गया रेट्रोस्पेक्टिव डेट 1975 से, 1 अक्टूबर 75 से लागू कर दिया गया, पेंडिंग मैटर्स में भी लागू है। सो इट अलाउज प्रिजम्पशन एज टू असेट्स, बुक्स ऑफ अकाउंट एटसेट्रा फाउंड ड्यूरिंग सर्च अंडर सेक्शन 132 और सर्वे अंडर सेक्शन 133A। ये पहले सर्वे नहीं था 292C में, लेकिन 2002 की साल में 1 जनवरी से सर्वे को भी इसमें ऐड कर दिया गया। और क्या प्रिजम्पशन होगा, पहला बात दैट सच बुक्स ऑफ अकाउंट, डॉक्यूमेंट्स, मनी, ज्वेलरी और वैल्यूएबल आर्टिकल एटसेट्रा बिलोंग टू सच पर्सन। जहां पर ऐड हुआ है ये माना जाएगा कि ये डॉक्यूमेंट, बुक्स ऑफ अकाउंट और ज्वेलरी अदर अवेलेबल सेट उस आदमी की है। दूसरी बात दैट कंटेंट्स ऑफ सच बुक्स ऑफ अकाउंट एंड डॉक्यूमेंट्स आर ट्रू, माने उसका कंटेंट है, लिखा हुआ जो भी उसमें है डॉक्यूमेंट में वो सही है। तीसरा बात है दैट सिग्नेचर इज ऑफ द पर्सन, बुक्स ऑफ अकाउंट एंड डॉक्यूमेंट्स which purport to be in the handwriting of a person are in that person's handwriting. In case of document जो स्टाम्प किया हुआ है, document stamped, executed or attested that it was duly done by the person by whom it purports to have been so executed or attested. माने कोई भी डॉक्यूमेंट को दलील मिल गया, कोई एग्रीमेंट मिल गया, उनको कागज मिल गया, तो ये समझा जाएगा जिस आदमी का रेड हो रही उसकी हैंडराइटिंग में है, उसका साइन किया हुआ है और उसने एग्जीक्यूट किया है उसको. The above presumptions will also be in case of requisition under section 132A. जैसे कस्टम ने रेड किया, ईडी ने रेड किया और कोई डिपार्टमेंट ने, डीआरआई ने रेड किया, तो वहां पर भी जो कागज मिले हैं उसके मामले में वो कागज बाद में डिपार्टमेंट को, इनकम टैक्स डिपार्टमेंट ले सकता है, तो उन मामलों में भी ये प्रिजम्पशन लागू होंगे. फिर देखिए एक सीबीडीटी ने एक इंस्ट्रक्शन दिया था काफी पहले 2003 में, जो इसमें दिखाया है, और उसमें क्या लिखा है, माने सीबीडीटी दिल्ली में बैठकर अनभिज्ञ नहीं है कि क्या हो रहा है, क्या सही हो रहा है, क्या ज्यादती हो रही है. तो देखिए इसमें रिफ्लेक्ट करता है वो बात. बोलता है इंस्टेंसेस हैव कम टू द नोटिस ऑफ बोर्ड वेयर assessees have claimed that they have been forced to confess undisclosed income during the course of search and seizure and survey operations. Such confession, if not based on credible evidence, you see it is not evidence, it has to be credible evidence, are retracted by the concerned assessees while filing return of income. In these circumstances, confession during the search and seizure and survey operation do not serve any useful purpose. So this is admitted by the CBDT. Then it says, it is therefore advised that there should be focus and concentration on collection of evidence of income which leads to information on what has not been disclosed or is not likely to be disclosed before the income tax department. Similarly, while recording statement during the course of search and seizure operation, no attempt should be made. You see what it says, no attempt should be made to obtain confession as to the undisclosed income. You see, it is categorically said that no attempt should be made, but in practical life, what is happening? In practical life, day in and day out, the authorities flout the above instruction in most of the cases, and it needs serious consideration and action to ensure that the action is taken against the erring officials. You see, the very word instruction from the top, from the highest authority, Central Board of Direct Taxes, and I am not aware whether a single action, an action even against one official has been taken by the government against the official who are taking or extracting the admission or disclosure of income during survey and search. So this is a serious matter. I have personally brought it to the notice of the board, and I think the government will either, you see, if they don't believe in implementing the instruction, they should withdraw the instruction, and they should say that yes, they can extract the disclosure, they can take any action, whether lawful or unlawful. If this instruction is surviving, if it is valid, then this is supposed to be followed seriously. Now we come to the basic things, that is the meaning of statement or admission. You see, the word statement is not defined in the Income Tax Act. So we refer to the dictionary meaning. Dictionary meaning is something that is stated. And Indian evidence says about it, Indian Evidence Act describes admission as an oral or documentary statement which suggests any inference as to any fact in issue or relevant fact, and which is made by a party or by a person concerned with him in any of the ways as described under section 17 to 23 of the Indian Evidence Act. Admissions are statements by a party of existence of a fact which is relevant to the issue in dispute. Statement may be either admission or denial of a fact. Statement may contain both the things. So you see, if we only read Income Tax Act or Income Tax rules, that is not enough. The other laws are very important to be referred to. I just refer to you Indian Evidence Act. Then you see the Supreme Court and other courts also had examined the issue, and it has been said that admissions are not conclusive proof. Admissions, though sometimes strong evidence, are however not conclusive proof of the facts admitted. But what a party admits to be true may reasonably be presumed to be so unless it is satisfactorily explained or successfully withdrawn. So long as they do not operate as estoppel, persons making admissions are at liberty to contradict them or to show that they are untrue or mistaken or made under misrepresentation or under coercion. You see, these four things are very important. They are at liberty to contradict them or to show that they are untrue or mistaken. ये फैक्ट्स का बात है, तो ये हम लोग को फैक्ट्स बताना पड़ेगा कि ये नहीं, ये फैक्ट है with the evidence, and made under misrepresentation or under coercion. So these things are very important, and just saying it in an affidavit or in the retraction that I made this statement under coercion or under misrepresentation, these are untrue or mistaken, this saying is not enough. That is to be sufficiently proved, because my own statement, which I already made, that goes against me. So we can contradict it, but there has to be sufficient proof. Thus, the effect of an admission is to shift the burden of proof to the party making the admission. Admissions play a very important role in income tax proceedings, as they generally bind the maker. You see, these are binding against the person who has made it. In the absence of any denial or explanation, therefore, an admission is almost conclusive regarding the facts contained therein. Though Section 31 of the Indian Evidence Act states that admissions are not conclusive proof of the matters admitted, yet admissions in the absence of rebuttal may conclude an issue in favor of development and against the SEC. These may operate as a estoppel against the provisions of the law. Under the Income Tax Act, also admissions bind the maker if these are not properly rebutted or retracted. Now we come to retraction of statement, the basic things. Even if an admission is made in a statement, the same cannot be held to be conclusive, as I already said. In every case, especially when the SEC or any other person whose statement has been recorded under Section 132(4) seeks to retract it and shows some genuine, concrete reason. However, retraction of statement made is viewed adversely by the Income Tax Department in most of the cases. Article 20, sub-article 3 of the Constitution of India says that no person accused of any offense shall be compelled to be witnessed against himself. This is based upon a legal maxim, which means that no man is bound to accuse himself. You see what has been stated in the Constitution, these things are there. But despite many things being in the Constitution of India, but still you see, so far income tax is concerned, we have to be very careful. And decisions where retraction of statement was held valid. I first refer to the Supreme Court case in the matter of Pulangot Rubber Produce Company Limited versus State of Kerala. The citation is given 91 ITR 18 Supreme Court. That says that admission is an extremely important piece of evidence, but it cannot be said to be conclusive, and the maker can show that it was incorrect. And it was also followed in many other cases, because the case I cited is Supreme Court case. It was also referred in S. Arjun Singh versus CWT, that is in 1989 case. And there are many other cases where it has been referred to. And now in some situations, the statement recorded has, and later on retracted, that retraction has been accepted in certain circumstances. First is statement recorded at odd hours. the retraction of statement which were given in an exhausted state and at odd hours was allowed. In this case, Kailash Ben Manhari Choksi, that is 2010 case, 320 ITR, the citation is given. So merely on the basis of admission, assessee could not be subjected to such addition unless and until some corroborative evidence. This corroboration, this is a very important word. Corroboration. And just if somebody makes the statement and if there is no other evidence with the department, then in that case, the addition cannot be sustained. So some corroborative evidence is found in support of such admission. The High Court also held that statement recorded at such odd hours cannot be considered to be a voluntary statement. If it is subsequently retracted and necessary evidence is laid contrary to such admission. I think many of us who are attending the program today, they have faced the search and seizure operations. So, and how the statement is extracted by the officials who are coming. Now you see, we deal with some more, then I will suggest you something. Then the Bombay High Court case, in the case of Lavanya Land Private Limited and others, it has said the 2017 case, considering that the concerned person retracted his statement, the Income Tax Tribunal held that merely on the strength of the alleged admission in the statement, the additions could not be made as the essential ingredients of Section 69C, enabling the additions were not satisfied. This was not a case of no explanation. You see, these sections 68, 69, 69 ABC, at many places we will find that it is mentioned that if some entry is found, some transaction is found, and if the assessee does not explain it to the satisfaction of the assessing officer, then it can be considered as income. So here the Bombay High Court said that this was not a case of no explanation, means we should not take any notice from the department in a lighter manner. We should make the best possible explanation in search cases as well as survey cases. Income Tax Tribunal concluded that the allegations made by the authorities are not supported by actual case passing agents. Bombay High Court dismissed the appeal of the department, stating that no question of law arose. On fact finding, ITIT order was final. And that is the admitted situation, that on the question of facts, tribunal's findings are final. Then another case, Krutika Land Private Limited. This is Supreme Court case, 2019 case. The High Court had held that since his documents did not belong to assessee, but were seized from residential premises of one Mr. D, who had later retracted his statement, no action under Section 153C could be undertaken in case of the assessee. It held that there was no material to conclusively show that huge amounts revealed from seized documents were actually transferred from one side to another. So additions under Section 69C were not sustainable. And you see, after the High Court decision, the revenue went to the Supreme Court, but the SLP was dismissed by the Supreme Court. Then we come mistaken understanding or on misconception of facts or on pressure. This is the case of Himachal Pradesh High Court, Satyendra Kumar versus CIT. It was held that it is true that the admissions made by the assessee constitutes a relevant piece of evidence. But if the assessee contends that in making the admission, he had proceeded on a mistaken understanding or on misconception of facts or on untrue facts, such an admission cannot be relied upon without first considering the aforesaid contention. Contention means retraction. You see, many a times, suppose the search is being conducted at more than one places. Here, one place, one gentleman is there, At other places, some ladies are there, or his brother is there, or his father is there. Then what is done many times that they tell to the other person, they say to the father that your son has accepted 10 crore rupees and he has accepted that these loans are bogus. But no evidence is shown to the father. It is verbally told. So they try to also get a statement from the father that yes, that is undisclosed income or bogus transaction. So these kind of tactics are many times adopted by some of the officers. Disclosure on pressure and without evidence. That was the case of the Ahmedabad tribunal in 2015. Assessee declared the sum under pressure, which was evident from the fact that no such corroborative evidence, asset, or valuables are found in the form of immovable or movable properties from his residence in support of the amount of disclosure, which was later on restricted but not accepted by the department. Income Tax Tribunal Ahmedabad bench held that the evidence ought to have been collected by the revenue during the search in support of the disclosure.
तो आप हाथ पैर दिखा रहे हैं, कल आपका बराबर का हो जाएगा। आपको समझा रहे हैं हम, ये क्या बोला थूक देगा आपको हम समझा रहे हैं, आप समझे नहीं ये बात। आज आप मेरा बात को नहीं समझेंगे, जिस दिन आपका कद का हो जाए।
Then the next case, the assessee entitled to modify or clarify the statement after verifying the necessary detail. Because at the time of search, the books of account may not be there with him, the staff, accountant may not be available, computer operator may not be there. So in the Surendra Pal Verma's case, the Chandigarh bench of tribunal, third member decision it is well known fact that the confessional statements made during the search are often vulnerable on the ground that the person giving such statement remain under great mental strain and stress. They also do not have relevant details, documents, and books of account at the time of giving such statements, in the absence of which precise information relating to the mode of utilization of such income and the year of such investment cannot be correctly furnished. The assessees are therefore entitled to modify or clarify the statements after verifying the necessary details from the relevant records at later point of time. You see, of course, the court has said it, but the person making the statement, he has to say it, that whatever I am telling is tentative, I will verify with the record and with the concerned people, then I will give the proper statement or I can modify this statement. So this thing they should keep in their hand. Evidentiary admissions are not conclusive proof, I already said, but this has also been shared by the Supreme Court in other case, that is Awadh Kishore Das versus Ram Gopal, 1979. Evidentiary admissions are not conclusive proof of the facts admitted and may be explained or shown to be wrong, but they do raise an estoppel and shift the burden of proof onto the person making them. The Supreme Court further held that unless shown or explained to be wrong, the statements are an efficacious proof of facts admitted. So the same thing you see comes again and again. There are various other cases on retraction where the retraction was accepted. The case of Gujarat High Court, again a Supreme Court case of Durga Prasad Moore. Then we have got Ahmedabad Tribunal, third member bench. Then we have got Amritsar bench, Jodhpur, ITAT, Pune IIT. In all these cases, some cases where retraction was not accepted. You see, somebody was pointing out something. Is there any problem? Now we come to the cases where retraction was not accepted. And the first case nowadays we hear a lot about the film stars. So I am also referring, but that may be the drugs cases or other criminal cases. We are concerned only with the income tax cases. So the first case I will talk to you is the 2018 case of Priyanka Chopra. In Priyanka Chopra's case, the case was in Bombay Tribunal and it also went to the Bombay High Court. It has been said that a search was carried out in the course of which various incriminating documents were seized. Assashi and her mother admitted certain undisclosed investment towards purchase of assets. Subsequently, Assashi's mother retracted her statement. The AO, however, added amount admitted by the admitted in the search as the Assashi's taxable income. It was only with reference to search and seizure material that Assashi's mother had given a specific amount to various heads wherein undisclosed income had been utilized. Further retraction was by mother, and there was no retraction whatsoever by the Assashi. Means Priyanka Chopra did not retract. Impugned addition was based upon incriminating material found or searched, and thus same was confirmed by the Bombay High Court. So we have seen that even in case of big film stars, the department has taken the view based on facts and law. Then we again come to Supreme Court, again a very recent case of last year, 2019. That is the Banalal Jat Construction Private Limited versus ACIT, reported in Taxman 106 Taxman 1.com 128. The AO made additions of undisclosed income on the basis of statement of director. Subsequently, he retracted statement. ITIT found that statement had been recorded in presence of independent witness. Confirmed addition made by the AO. High Court held that mere fact that the director retracted his statement at later point of time could not make said statement unacceptable. Burden lay on Assashi to show that admissions made was wrong, and such retraction had to be supported by a strong evidence showing that earlier statement was recorded under duress and coercion. And the SLP was filed by the Assashi, but that was dismissed by the Honorable Supreme Court. You see here, some words are there. The tribunal has noticed that the statement was recorded in presence of independent witness. Now, who are these witnesses? When a search is carried out, usually who are the witnesses? Witnesses are supposed to be independent. They are supposed to be respectable people of the locality. But in practical life, who are made the witnesses? Generally, the servants in the house or in the premises, they are made the witnesses and they do not understand anything about income tax. But if we have got the respectable persons of the premises as witnesses, and if they remain in the house, then later on, if there is any high-handedness or anything wrong by the officials, they can also give an affidavit that something wrong happened, and that is very important. But the servant whose signature is obtained when the search party enters, once the signature obtained on the search warrant, that we call authorization, and at the end, when the search is concluded, again the signature is taken. And during the whole time, they are not aware of as to what is happening. So we should insist that the department should use independent witnesses, respectable gentlemen as witnesses, and not the servants. Sometimes you see the fact of life is that even a person where search is being conducted, he is also happy that his own people, the servants, are used as witnesses, because he feels that if a neighbor or any other gentleman of the building or premises, respectable person, if he comes, then you see it will expose him. Expose him means he will also come to know what right or wrong I have got in terms of the jewelry or in terms of black money, in terms of the unaccounted for money. So you see both sides of coin are there. One has to be very careful. Then you see admission on the basis of loose slips. This is a very relevant thing. Admission on the basis of loose slips or writing pads represented own money payment made for purchase of property. You see, many parties are in the habit and even their people in the factories and other places, they record everything. And in that loose slips or in the rough writing pad, they write all transactions, be it accounted for, or there may be some transactions which are unaccounted for. So, but this is very dangerous. These kind of record keeping, I've seen myself in many cases that has been seized in survey as well as search. And these are used, and these may be rightfully used by the department against the SSC. I just simply cannot say that these are only the loose sleeves, these are only the writing pad. If that loose sleeves or writing pads are disclosing or indicating the sufficient evidence against the SSC, then you see, just saying that this is not my normal books of account, this argument may not suffice. So we come to the cases. Madras, first, that is a comparatively recent case, 2018 case, Madras High Court. In such, certain loose slips were recovered, which showed several entries pertaining to cash and check transactions in respect of purchase of a property. She accepted the statement that slips represented own money payment made for purchase of property in question. Later on, SSC retracted and claimed that loose slips were only dumb slips or dumb documents. ITAT rejected claim of SSC and confirmed addition under section 69. As High Court held that since notings in loose slips were clear, see what High Court has noted, that notings in loose slips were clear. Retraction made by SSC after period of 2 years was rightly rejected as an afterthought. You see, the hint here is that if anybody wants to make some retraction, it should be made as soon as possible after the search. And if we say make some retraction after 2 years, the court has noticed that no, it is not valid. And you see, when we are talking of this recording on slips or loose documents, many times some people suppress some zeros. Suppose some transaction is say 5 lakh. So they may be removing 3 zeros so that the amount will look lesser. But you see, at the same time, if in the same document, same slip or writing pad, if there is some bank transaction, suppose I have deposited in the bank 5 lakh rupees and I have written in that loose document 5,000 rupees. And for the same day, if the bank statement is verified, the departmental officials found that it is not 5,000, it's 5 lakh rupees. Means how many zeros are suppressed? 2 zeros are suppressed. So in that case, in case of other entries in the same document, the department can take a view that yes, in all these transactions, 2 zeros are suppressed. So one has to be very, very careful. Many people you see write these rough notings, rough transactions by pencil. That also happens. Sometimes whatever documents are found, there the date is not mentioned or proper description is not there. So wherever date is not mentioned, there the SSCs take the view that this does not relate to this year. These are the rough papers lying there. But you see, it is a difficult course to prove what we want to say. Then you see some more cases, again a Supreme Court case, old case, Narayan Bhagwantrai Gosavi. Here the court said admission is the best evidence. You see, in some cases we found that the Supreme Court said that admission is not the conclusive proof. But in this case, the Honorable Supreme Court said that admission is the best evidence that an opposite party can rely upon, and though not conclusive, here again they said, though not conclusive, yet would be decisive of the matter unless successfully withdrawn or proved erroneous. Proved erroneous is a question of fact. So with the evidence, we have to prove that it is erroneous. The other case, Gujarat High Court, Fakir Muhammad Haji Hassan, there the Gujarat High Court upheld the department's action of treating the amount as deemed income. Then Ahmedabad Tribunal in Manarlal Kasturchand Chokshi, they say that proof of threat. You see, here it was pleaded that there was threat or coercion. So the court says that proof of threat or coercion is necessary for valid retraction. Means the person who is retracting, he has to prove that yes, there was a threat, there was a coercion. As I hinted you earlier, how you can prove it? That at the time of such there was a threat or there was a coercion. If there are independent, respectable witnesses, if they give an affidavit that these kind of things happened, then that is acceptable by the department. The allegation that the SSC was tortured and harassed by the search team and was forced to make an admission is not enough. Then other cases where retraction was not accepted, I am not going into the detail, but we have listed the cases, and these listed are various cases of the Income Tax Tribunal, Bombay, Pune, Bombay High Court, again Pune Tribunal, then Bombay Tribunal, Bombay High Court, Bombay High Court, again Bombay High Court. All these citations are there. The organizers may share this PPT with the participants. Then you see, we now come to some relevant points in case a statement is to be retracted. The retraction must be made without delay. That is the Ahmedabad Tribunal's case, 2011. A belated retraction would fall in the category of afterthought. That also we have seen in one of the cases. And this was in the case of Council of Institute of Chartered Accountants of India versus Mukesh R. Saha. That is 2004 case, Gujarat High Court. Evidence is needed to corroborate reasons for retraction. You see, as there is a burden on the department that they have to corroborate the admissions made for making the additions. Likewise, there is a need that the SSC should also corroborate when they are retracting the statement, where earlier they have admitted certain extra income. So merely mentioning that the statement was recorded using undue influence, threat or coercion, or that there was a mistake of fact or law may not be enough. What has to be seen is how clearly the same is spelled out and what evidence has been attached to demonstrate the same. So this is again a Gujarat High Court case, 2013. Then one case is Roshanlal Sancheti, that is Rajasthan High Court case, recent case 2019. That says retraction ought to have been generally made within reasonable time or by filing complaint to superior authorities or otherwise brought to notice of the higher officials by filing sworn affidavit or a statement supported by convincing evidence. You see, in some cases we have found that the retraction has to be filed before the officer who had obtained the statement. So we should file before him also, before higher authorities also. And when we talk of an affidavit, let me tell you something practical. You see, it is good to make an affidavit, but you see, affidavit can be made before a notary public. You see how notary publics are signing the affidavit. I need not tell you. Just by paying 10 rupees, 20 rupees, even if the person does not go, even then that is notarized. But it is advisable that in case of retraction, the party who is making retraction, he or she should himself or herself to go to the court and preferably the retraction affidavit should be signed, should be made before the first class magistrate of a court. There it is not possible that you just send the document to notary and it is verified. It is not possible. One has to go with the ID card and one has to go himself. And the honorable first class magistrate, he may be asking you some question also. They usually do not ask, but they may ask, you should be prepared. Then you see statement for 2 days and 2 nights can't be considered to be voluntary. Statements recorded by the search party during the search of more than 2 days and 2 nights cannot be considered to be free, fearless, and voluntary. All the at the most, what was expected to say was that certain income from the business was not disclosed, but putting in the mouth of the SSE that so much amount was not accounted for or was unaccounted and concealed would itself indicate that the admission was forcible and not voluntary. There was no supporting evidence to confirm the additions except the statement. This was the case of Bombay Terminal, Deepchand and Company versus Shetty 95 case. So you see where the whatever is disclosed on estimate basis without any basis. So there the tribunal has taken this view. You see, in this case, there was a raid only 2 days and 2 nights. But I am aware personally in case of one of my clients, where the search was conducted continuously for 7 days and 7 nights, and they did not get anything. They wanted that the party should declare 50 crore rupees. And my client said that I am not going to declare 50 rupees. What you are talking of 50 crore? You have not found any evidence of any undisclosed income or undisclosed asset. What for you are asking me to declare 50 crore? And then after waiting for so many days and so many nights, they told the search party that unless until you conclude your search, tomorrow we will be moving the Honorable Bombay High Court. Then they left. And when the assessment was completed, not a single penny was added by the AO. Means the assessment was completed as per return. So you see, departments sometimes have suspicion that this party is a big party, they might have a lot of black money, or they might have invested in a house which they are constructing, some black money. So in that impression they go, but sometimes they have to come back empty-handed. Now retraction after obtaining copy of statement on ground of mistaken belief. You see, in none of the cases, the search officials are giving you a copy of the statement recorded. They will say, okay, this will be given to you by your assessing officer. And the law provides that the copy of statement is required to be given by the officer only when it is going to be utilized against the assessee. At that moment of time they will give. Means when the assessment or the search assessment will be taken up. So before that, suppose you want to retract. So how the party knows that what I said during statement, he does not have any noting, no copy was given to him. So in such a situation, you see the party applied before the officers that I need the copy. You see, retraction after obtaining copy of statement on ground of mistaken belief, either of fact or law. Statement of the SEC cannot be sole basis without any cogent and corroborative evidence. You see, only on the basis of statement, addition cannot be made without any cogent and corroborative evidence. This was the Pune Tribunal, 2012 case. Admissions made at the time of such action is an important piece of evidence, but the same is not conclusive. It is open to the SSC who made the admission to show that it is incorrect and the same was under mistaken belief. You see, here the clue is that if the copy of the statement was not given and it is not given, in that case, immediately on the second day, you should apply to the search official authorized officer that please provide me, I do not remember what I said, please provide me the copy of the statement so that I can examine whether what I said was true on facts or in law or I misunderstood something. So then I will take future course of action as per law. So that letter duly stamped and received, that will help. And in that case, you see, if somebody is getting the certified copy of the statement after 1 year, and immediately after getting that, if you are making the retraction, that is good enough. But in practical life, something, let me tell you, one second.
आलोक जी, जिनका कोई जिज्ञासा वो हैंड रेज कर दे।
सभी से निवेदन है, कोई भी अपनी कोई जिज्ञासा रखनी चाहे तो वो अपना हैंड रेज
You
करके
see, in
रखें।
practical life, please listen. In practical life, immediately after the search is complete, you should call the assessee and you should ask him as to what was asked and what reply you made. So he may not be remembering 100%, but whatever he can recollect, he can tell you. So that is a good habit. Now statements recorded shall be treated as evidence. The statements recorded shall be treated as evidence in the proceedings under the Income Tax Act as long as statement is not restricted. If the assessee comes forward with the plea that his statement was recorded under threat or coercion, the evidentiary value of statement suffers a serious dent. Therefore, where the assessee retracts a statement given under section 132(4), the AO is required to bring material on record which corroborates the statement. That is also the responsibility of the department. This is Telangana and Andhra Pradesh High Court judgment of 2014. The AO may cross-examine the deponent after affidavit or retraction is filed. You see, this is very important. Once the retraction is filed, the assessing officer is entitled to summon the person who has made the retraction, and he can cross-examine that on what basis he has made this retraction. If the AO does not cross-examine, the averments which are made in the retraction affidavit are treated to have better evidentiary value. So this thing we should keep in mind. Now, principles of natural justice. The case judicial bodies should generally read in the relevant section a requirement of giving a reasonable opportunity of being heard before an order is made, which will have an adverse civil consequences for parties affected. See, this is the Jodhpur High Court case, and this was also held by the Honorable Calcutta High Court. The Honorable Justice Kalyan Jyoti Shangupta was there. And there it has been said that even if in that particular section the principles of natural justice are not imbibed, even in that case, it is mandatory for the income tax department or concerned official to give the opportunity, proper opportunity, and follow the principles of natural justice. You see, I had hinted something about the loose sheets earlier, but you see, there are some very important cases. Supreme Court case. You might have heard CBI versus VC Shukla, that is popularly known as Jain Hawala case. Jain Hawala Khan. So the actual name of the case is CBI versus VC Shukla. And this is 98 case, Supreme Court case. Loose sheets have been ruled out as of any evidentiary value. Loose sheets cannot be treated as account books of the party. Even if it is taken as an informal accounting, it is not the record of the assessee. That was held. That was not a case relating to income tax. But you see the principles laid down by the Honorable Supreme Court, even this can be used in the income tax matters as well. Then we have got P.B. Kalyan Sundaram's case. This is again Supreme Court case. And the Supreme Court affirmed the decision of Madras High Court, and it was said that the additions made on the basis of loose sheets were deleted on ground that vendors' contradictory statements could not be relied upon. Then State of Andhra Pradesh versus Chimalapatti Ganeshwara Rao, that is again Supreme Court case. It was held that absence of corresponding entry in the accounts of the opposite party precludes the alleged transaction. Then the fourth case is Mahashay Ganesh Prasad Rai versus Narendra Nath Sen. That is also a Supreme Court case, but old case. Loose paper seized could not be regarded as accounts within the meaning of Section 90 of the Evidence Act. And this has been followed in many cases. I have given one case of Income Tax Tribunal, Bangalore. Then SP Gramophone Company versus CIT, that is 1986 case of the Supreme Court. It was held that an unsigned paper containing allocation of profits among the parties has no evidentiary value. It was also referred in many other cases thereafter. Then CIT versus Atma Valves Private Limited, this is Punjab and Haryana High Court. The AO was not justified in estimating the sales on the basis of loose slips without substantiating that the SSE has actually made the sales. Then the Gujarat High Court says in Molly Kumar's case that notings on loose sheets of paper are required to be supported or corroborated by other evidences, which may include the statement of a person. And then Akra bench of the tribunal, third member bench decision, Ravi Agriculture Industries, very famous case. There also these loose sheets were not admitted as evidence. SP Goyal versus Deputy CIT, Bombay Terminal, third member judgment. So these things are there. Then you see, nowadays, why people, or even earlier, why people are inclined to make a disclosure during search. If a disclosure is made during search, the burden of penalty is much lesser. And now, according to the latest provisions of Section 271 AAB 1A, the penalty provisions in case the disclosure is made, it says that if search has been initiated under Section 132 on or after 15 December 2016, assessee shall pay by way of penalty a sum at the rate of 30% of the undisclosed income of the specified previous year if the prescribed conditions are fulfilled. Now, what are the prescribed conditions? Assessee in the course of search in a statement under Section 134 admits the undisclosed income and specify the manner in which such income has been derived. Means he has to admit undisclosed income, he has to specify the manner in which such income was derived or earned, and he has to substantiate the manner in which the undisclosed income was derived. Then he pays the tax together with interest in respect of the undisclosed income within the due date of filing of the return of income. And lastly, he has to furnish the return of income for the specified previous year, declaring such undisclosed income therein within the due date of filing of the return of income. So these four conditions are cumulative. These are to be fulfilled. And in case the income is disclosed during search, then the tax is charged only at the rate of 30% against how much can we tax under Section 115 BBE? It is the aggregate of 78%. 115 BBE now provides after demonetization that 75% is the tax and surcharge and 4% is the cess, education cess. So in aggregate that makes 78%. And if the assessee himself does not declare in the return, if the assessing officer does it, then there is 10% penalty. In that case, the burden is 84% plus interest. So that is why the people are lured to declare the income, undisclosed income during search. And no penalty under the provisions of Section 270A and Section 271(1)(c) shall be imposed upon the assessee in such cases. Means when this section is applied, in case of search where the income is declared, 271A(b) is applicable. Then the other two sections, 278 and 270A and 271(1)(c) will not apply. Then burden of proof in case of retraction. See, there is a burden cast on assessee to prove the detraction or rather disprove the admissions made. It is not a shifting of the onus, but a new burden cast on the assessee to disprove the earlier admission having evidentiary value. Otherwise, retraction made by assessee can only be considered as a self-serving afterthought and no reliance can be placed. This was the Kerala High Court case, CIT versus Abdul Razak. Then you see, again we come to Rajasthan High Court case. It says burden to prove retraction lies on the SSC. It should be made as soon as possible after search, either by filing a complaint or otherwise brought to the notice of the higher officials. This is CIT Bikaner versus Ravi Mathur. And this was also Allahabad High Court. I have given the citation, S.C. Gupta's case. Now conclusion on admission and retraction. An admission in statement under section 134 is vital, and the department may make addition in income based on such statement unless successfully retracted, as has been held in many cases. The retraction should be made properly. So बड़ा कर दो. ये बंद करना. So retraction should be made properly and at the earliest possible opportunity, and establishing the situation as to how the facts stated in the statement are mistaken on facts. We have to clearly state and prove that how the statements are mistaken on facts or in law, and if necessary to prove that the statement was recorded with caution and pressure. You see, that was all about the admission and retraction. You see, now you see in case of survey, as Kakraji told in the beginning, that earlier the survey could be conducted even by the assessing officer and wherever required with the permission of joint commissioner. But now the government CBDT has given the instruction recently that survey under the income tax law under section 133A can be conducted either by the investigation wing or by the TDS wing. And you see, interestingly, the CBDT has also said that the survey under section 133A should be conducted only in limited cases where it is most necessary. Means it should not be in normal cases. Wherever it is the most necessary, only there it should be conducted. Now we just go through the relevance of electronic or digital evidences. You see, first of all, nowadays we are aware, for many years we are filing the returns online, income tax returns. And now with every year passing, it is becoming almost essential that almost all taxpayers, haven't except the senior citizens or a few other exceptions, everybody has to file the return electronically. And recently we have seen that since last year that assessments are also to be completed online. Earlier our ITO himself was doing the assessment, jurisdictional ITO, but now it has been provided that it will be faceless assessment. Means if I am in Calcutta, the NEAC may decide that the assessment will be looked after by an assessing officer of Bombay, Delhi, Chennai, Bangalore, or any other place. Likewise, from day before yesterday, the faceless appeals have been introduced. The faceless appeal scheme has been already notified day before yesterday. Now the appeals which were filing online, we were already filing the appeal before CIT appeal online, but now those hearings of the appeals and the order of those appeals will also be taken up in a faceless manner. Means if I am an appellant here in Calcutta, any other commissioner may take care of the appeal, and first one commissioner will take hearing and then he will make a draft order. That draft order and documents will be sent to some other CIT appeal. After going through the facts of the case, the legal issues involved, and the draft order, the other commissioner will finalize it. Means he will make it sure that whether the order which has been drafted, whether that is correct or not. So the government is trying to take full precaution to be doing justice in the case of the appeal. And as soon as we file the appeal, we should be ready with our written submission and documents, and the government will allow us to furnish the written statement and necessary evidences, which we should file in the website of the Income Tax Department, where this facility will be provided. We have recently seen even how the chat on the mobile, WhatsApp, emails, how those are being considered as evidence, even in big cases which are now being talked out in Bombay. So this electronic document does not only mean the documents which are in the computer, but also in any other mode. All those may be considered as the documents. And the department is entitled, in case of survey and search, to take copy of the laptop, hard disk, computer hard disk, and they can also obtain detail of the talks on computer. In case it's not possible to obtain a copy of those hard disks, then sometimes they also seize the laptop or the computer. So all these things are happening. Now a few points relating to, you see, this Information Technology Act was enacted to provide legal recognition to transactions carried out by means of electronic data interchange. This was in the year 2000, means 20 years ago, by means of electronic data interchange and other means of electronic communication, which involve the use of alternatives to paper-based methods of communication and storage of information. The said enactment brought amendments in the Indian Penal Code, the Indian Evidence Act, the Bankers Book Evidence Act, the Reserve Bank of India Act, and that was also followed by the amendment in the Income Tax Act. Now there are 3 amendments in the Income Tax Act. I will deal briefly with all the 3. The first is by way of first amendment in the year 2001. You see, Information Technology Act came in 2000, but immediately thereafter in 2001, income tax law was changed. Section 2, subsection 12A was inserted to give legal recognition to the books of account maintained on computer, and section 222A, section 2, subsection 22A was inserted to provide definition of document which included electronic record as defined under the Information Technology Act 2000. Now, how that is defined? Is electronic record will include data, a record or data generated, image or sound stored, received or sent in an electronic form, or microfilm or computer generated microfile. So the scope, you see, the definition of document according to the Information Technology Act is very wide, and that definition will also apply for the purpose of income tax. Now, definition of electronic record, it says it will cover person in possession of computer, storage device, server, mobile phone, iPod, or any such device. The above amendment has thus specifically given recognition to electronic record as admissible evidence at par with the document, physical document. Power to seize a document during a search and seizure operation under section 132, and power to impound copy of document during survey under section 133A has also been automatically extended to electronic records as a result of the said amendment. There was the first amendment in 2001. Now we come to 2009 amendment of section 132(1) by Finance Act 2002, and also amendment of section 282 subsection 1. The Finance Act 2002 inserted provisions of section 132(1) IIB facilitating access to the electronic devices, including computer, containing documents of books of account in the form of electronic records, by making it obligatory for the person under control of such device to afford necessary facility to inspect such records. So that was the second amendment. There the section 132(1) IIB was inserted. Then in 2009, Finance Act was amended. 282(1) clause C was inserted to provide that service of notice in the form of any electronic record as provided in Chapter 4 of Information Technology Act will constitute valid service. Means whatever email is recorded with the Income Tax Department, the department can send notice on that email ID, and that will be valid service. So we should all check whether our client's email ID is properly mentioned or not. You see, even nowadays, the big agencies now functioning in Mumbai, they are sending the notices or summons by email. And even they are sending the summons by WhatsApp, by way of mobile phone. You see, the other relevant sections which were added after section 65, these were inserted in the Indian Evidence Act. That is section 65A and 65B. Amendments made to the Indian Evidence Act to incorporate reference to electronic records along with the document giving recognition to the electronic record as evidence. Special provision as to evidence relating to electronic record inserted as section 65B. They govern the integrity of electronic record as evidence, as well as the process of creating electronic record. They impart faithful output of computer the same evidentiary value as original without further proof of or production of original. Accordingly, while handling any digital evidence, the procedure has to be in consonance of these provisions. So this is very important. Income Tax Act alone is not enough. We have to read Income Tax Act with Indian Evidence Act. And these, you see, these amendments in 65A and 65B of Indian Evidence Act are very important. Of search and seizure of physical evidence versus digital evidence. Retrieval of data from data storage devices. The dynamics of computer searches turn out to be substantially different from the dynamics of conventional searches. The seizure dynamic of premises search is replaced by things like scan, acquisition, search, and identification of evidences dynamics. Computer forensics analysis typically performed subsequent to a search operation at the income tax officer or by cyber forensic laboratory. You see, sometimes we feel that, you see, I've got a passcode or password and my data, accounting data cannot be approached by the income tax department or by the search authorities, but that is a wrong notion. Department has got all capabilities of breaking the passcode or password, and even the data in the hard disk which are deleted, that can also be restored by these officials. So one has to be very, very careful. Weeks after the computer has been seized from the target premises, an analyst may comb through the world of information inside the computer and try to find the relevant evidence. The rules and procedure governing search of data and its acquisition are the process of being settled. You see, there are many digital devices. I am not going through it, and I think it is already 15 minutes past 1 o'clock. Do you want me to continue?
Little bit more you can.
Huh?
10-15 minutes you can.
Now I deal with another 10 minutes and complete.
Okay. Okay.
You see, these things are necessary to know with the changing time. These digital devices, digital evidences are very, very important. You see, we may come across a wide range of digital evidences which include email, word processing documents, database tables, files saved from accounting programs, digital photographs. You see, is worth noticing digital photographs, ATM transactions, and instant message histories, internet browser histories, the content of computer memory, computer backup, global positioning system tracks, digital video or sound files, and this data stored in various types of devices. And you see now to list it out: desktop computer, pen drives, hard drives. You see many people what they are doing, they are taking copy in pen drive from the computer, but that pen drive is equally harmful. The data which are of no use or unaccounted for, it does not serve any purpose to keep it in pen drive. Hard drives, mobile phones, electronic organizers, iPad, personal digital assistant, and other handheld devices, smart cards, dongles, and biometric scanners, display monitor, screens of mobile phones, answering machines, then local area network, we call it LAN card, and networking interface cards, modems, routers, hubs, and switches, servers, removable storage device like SD cards in mobile phones, scanners and copiers, digital cameras, kindly mind it, digital cameras, CD, DVDs, fax machines, global positioning system, I have told already, cloud data servers, persistent evidence, or it may be volatile evidences. And you see, then you see these people department also have got the services of cyber forensics that will also help the department. Now you see seizure of digital data. The section 132 apply to retrieval of data from data storage devices and seizure. The dynamics of computer searches turn out to be substantially different from the dynamics of conventional search. The identification of evidence, dynamic of premises search is replaced by things like I already told. These are replaced by electronic evidences and removing the difficulties. Now, wherever search is conducted, the persons available there, they are duty bound that they have to provide the access to digital evidences. It requires any person in possession or control of books of account or documents maintained in form of electronic record to afford the authorized officer necessary facility to inspect such books of account and documents. Such person is obliged to provide, besides the physical access and access to the data, which include disclosing the passwords. You see, the person is duty bound to disclose the passwords, details of operating system and software and their functioning. And Section 275B of the Income Tax Act provides that failure to comply with the above provisions of 132(1)(ii)(b) will be a punishable offense by imprisonment up to 2 years. So the person who is available at the spot of search, be it office or residence, they have to cooperate with the department. And there are many cases on digital evidences, Supreme Court cases and others. I'm not going through it. So I must thank you all for giving me a patient hearing. And I hope if some of the things and cases what I have narrated to you, if we can use in our practical life, the practice of search and seizure cases as well as survey cases is very useful. The person who is dealing with that, any professional, he may get good amount of fees, and he may, in addition to fees, if he can successfully conduct the case, then he gets a lot of satisfaction. His client also gets a lot of satisfaction. So we need not have any kind of apprehension, reservation, or fear in our mind in dealing with these cases. Thank you very much. Thanks to all.
धन्यवाद नारायण जी, आपने एक समसामयिक विषय पर बहुत ही सारगर्भित वक्तव्य दिया और हम सबको अनुग्रहित किया। अब मैं निवेदन करूंगा, हमारे साथ जुड़े हुए हैं हमारे टीपीएफ के राष्ट्रीय मंत्री श्री सुशील जी जैन, कि वो अपना वक्तव्य दें। सुशील जी।
यस, हेलो, हाँ आवाज आ रही है?
सुशील जी।
हाँ आ रही है।
हाँ आ रही है।
ये नारायण जी स्क्रीन बंद कर दीजिए अगर आपका हो गया है अभी। स्क्रीन शॉट बंद।
सादर जय जिनेंद्र। सभी टीपीएफ कोलकाता और टीपीएफ साउथ कोलकाता व लीगल एड के संयुक्त तत्वावधान में आयोजित इस कार्यक्रम में आज नारायण जी को सुना। नारायण जी एक एक्सपर्ट हैं ही, और तेरापंथ प्रोफेशनल फोरम में आप निरंतर आते रहे हैं। आज आपने जिस सूक्ष्मता के साथ सर्च, सर्वे, सीजर और एविडेंसेस, डिजिटल एविडेंसेस के बारे में जो जानकारी दी, निश्चित रूप से हमारे जितने भी उपस्थित संभागी हैं, दे मस्ट हैव एनरिच्ड देयर नॉलेज बैंक। मैं नारायण जी को धन्यवाद देना चाहूंगा। आज हमारे बीच में उपस्थित हमारे टीपीएफ के सीनियर मेंबर कैलाश जी गोयल एडवोकेट भी उपस्थित है। उन्होंने भी इस उम्र में उपस्थिति दर्ज कराई है, उन्हें भी बहुत बहुत साधुवाद देना चाहूंगा। काकड़ा जी और अन्य सभी प्रबुद्धजनों को भी बहुत बहुत धन्यवाद। तेरापंथ प्रोफेशनल फोरम राष्ट्रीय इसी तरह के प्रोफेशनल कार्यक्रम आयोजित करती जा रही है। आज भी हमारे देश भर में कम से कम 10 शाखाओं ने वेबिनार्स वगैरह आयोजित किए हैं, कुछ चल रहे हैं, कुछ और शाम को होंगे। और एक जानकारी मैं और देना चाहूंगा, हमारे टीपीएफ के वरिष्ठ सदस्य जिन्हें टीपीएफ गौरव से सम्मानित किया गया है, कैलाश चंद जी जैन, केसी जैन साहब, जो रिटायर्ड प्रिंसिपल चीफ कमिश्नर ऑफ इनकम टैक्स है, आज शाम को 8:15 बजे उनका भी एक विशेष वेबिनार में रखा गया है, शाम को 8:15 बजे तेरापंथी महासभा के माध्यम से। उसमें भी विषय ये अभी के प्रासंगिक विषय रहेंगे। मैं सभी से निवेदन करूंगा कि उस सेमिनार में भी भाग लें, और जितने भी प्रोफेशनल्स हैं वे अधिक से अधिक प्रोफेशनल्स को तेरापंथ प्रोफेशनल फोरम के साथ जोड़ें, ताकि हमारा इंटरेक्टिव सेशंस वगैरह का कार्यक्रम और अधिक सुचारू रूप से चल पाए। मैं पुनः आज दोनों शाखाओं को और नारायण जी को, काकड़ा जी को, सभी को बहुत बहुत धन्यवाद देता हूं और आगे के कार्यक्रमों के लिए शुभकामनाएं प्रेषित करता हूं। जय जिनेंद्र।
धन्यवाद सुशील जी कि आपने हम सबको अपने 2 शब्दों से अनुग्रहित किया। अब मैं आग्रह करूंगा हमारे कोलकाता रीजन के प्रेसिडेंट श्री कमल जी जैन को कि वो अपना वक्तव्य रखें।
जय जिनेंद्र। सबसे पहले तो मैं हमारे राष्ट्रीय अध्यक्ष श्री निर्मल जी कोटेचा, सुशील जी चोरडिया, सुशील जी चोपड़ा और वरिष्ठ हमारे मेंबर कैलाश जी गोयल को धन्यवाद देता हूं कि उन्होंने अपने बिजी शेड्यूल के बाद भी यहाँ अटेंड किया। नारायण जैन जी ने सबसे पहले हम लोगों को ये बताया कि अनुचित तरीके से पैसा छुपा कर रखना, टैक्स चोरी करना अब आसान नहीं रह गया है। हमें भी मोदी जी का साथ देना चाहिए, तन से, मन से और कर्तव्य से। फेसलेस असेसमेंट उसी का एक प्रारब्ध है और अपील भी चालू हो गई है फेसलेस। अब आज के सब्जेक्ट के ऊपर नारायण जी ने बहुत ही सुंदर तरीके से, सूक्ष्मता से सभी कुछ अपना व्यक्तित्व रखा और अपना विचारों को शेयर किया। बेसिकली सेक्शन जो है 132(4) का जो इन्होंने पूरा डिटेल में आपको एक्सप्लेन किया है, और उसके बाद में एक मिनट, और उन्होंने बहुत से केस लॉज देकर सब चीज समझाई है रिस्ट्रिक्शन के बारे में। बेसिकली उन केस लॉज में हाई कोर्ट के केस भी हैं, आपके सुप्रीम कोर्ट के केस भी हैं। पुलंगगढ़ रबर प्रोडक्शन केस के बारे में बताया, कैलाश बेन चौकसी के बारे में बताया, लारण्या लैंड प्राइवेट लिमिटेड एंड अदर्स के बारे में बताया, कृतिका लैंड प्राइवेट लिमिटेड के बारे में बताया, सतेंद्र कर्मकार HF जो है उसके बारे में बताया, और सुप्रीम कोर्ट का मन्नालाल जैन के बारे में भी, मन्नालाल के केस के बारे में भी बताया। इन सब केसों के माध्यम से उन्होंने अपने बात को पूरे विस्तार रूप में रखा और एक एक पॉइंट पर उन्होंने अपने इस बातों की व्याख्या की। सेक्शन 212A एंड सेक्शन 222A के बारे में भी उन्होंने इनकम टैक्स में उसके बारे में बताया, और अमेंडमेंट जो हुए सेक्शन 132(1) में और 2002 में हुए, और 281(1) में 2009 में इफेक्टेड हुए सर्विस। अच्छा, उसके बाद में उन्होंने सर्विस टैक्स के नोटिस के बारे में बताया कि आजकल इलेक्ट्रॉनिक मोड से सर्विस नोटिस आती है, इसलिए इलेक्ट्रॉनिक एड्रेस जो आपका दिया हुआ है, मेल जो दिया हुआ है, वो सही होना चाहिए। अदरवाइज नोटिस आपके पास आ भी गई और आपको पता नहीं चलेगा, तो हो सकता है कि उसमें एक्सपायरी हो के आपका लंबा केस लग जाए, पैसा लग जाए। तो इसीलिए हमको सचेत रहना पड़ेगा कि नोटिस कभी भी आती है, हम अपना मेल चेक करते रहें। अब मैं नारायण जी का धन्यवाद देता हूं कि उन्होंने अपना अमूल्य टाइम हमें देकर अनुग्रहित किया है, और मैं चाहता हूं कि भविष्य में जब भी जरूरत पड़े तो उनका साथ हमें मिले। अब मैं चल रहा हूं कि जो भी आज इस वेबिनार में अटेंड किए हैं उन सबको भी मैं धन्यवाद देता हूं कि उन्होंने अपना टाइम निकालकर और हमें अनुग्रहित किया है और अटेंड करके इसकी मर्यादा को बढ़ाया, मान मर्यादा को बढ़ाया है। और धर्मचंद जी धारेवाल जी ने बहुत मेहनत की है, साथ साथ में आलोक जी ने भी काफी मेहनत की है, जिसके कारण से आज हम लोग अच्छे पार्टिसिपेंट इकट्ठे कर पाए। धन्यवाद सभी को मेरी तरफ से धन्यवाद।
कमल जी, मेरा सुझाव है कि जतनलाल जी बर्डिया साहब से और गोयल जी से यदि वो चाहे तो एक एक दो सब लाइन मिनट बोले हो।
जरूर जरूर
जरूर जरूर। गोयल जी को बोला
कैसी गोयल जी व्यक्त करें। गोयल जी हैं, तो मैं गोयल जी से आग्रह करूंगा, आदरणीय श्री गोयल जी, कि वो अपने विचार व्यक्त करें।
गोयल जी शायद निकल लेफ्ट हो गए। गोयल जी,
जतनलाल जी बढ़िया है। जतनलाल
जी मैं हूँ।
हाँ जतनलाल जी।
नमस्कार नारायण जी एंड सभी पार्टिसिपेंट्स को मेरा नमस्कार। नारायण जी के बारे में तो हम सभी जानते हैं। नारायण जी इतने अच्छे एडवोकेट, ऑथर, मतलब उनकी बहुत हाई पोजीशन है होने के बावजूद भी वो इतने काइंड हार्टेड है। जब कभी भी हम उनके पास में जाते हैं, कोई भी प्रॉब्लम लेकर के, जो भी अमेंडमेंट्स होता है उस पर बोलने के लिए वो हमेशा अपना समय देते हैं। ये इनकी बहुत विशेषता है। और एक विशेषता और है नारायण जी की कि ये जैसे अपने लोगों के बीच में इतनी सुगमता से, इतनी सरलता से अपनी भाषा में आज 2 घंटे का सेशन चला, मुझे ऐसे लगा कि ये आधा घंटा ही हुआ है। मतलब इतनी इनकी जो समझाने की कला है और एक एक साइटेशन इन्होंने दिए कि आदमी सुनते सुनते चाहता है कि और ज्यादा सुनूं। ये इनकी विशेषता है। और ये विशेषता डिपार्टमेंट के सामने भी है। डिपार्टमेंट में सीबीडीटी के ऑफिसर्स हैं, फाइनेंस मिनिस्टर निर्मला सीतारामन के सामने यदि इनको बोलना है तो बड़ी दबंगता से वो आवाज उठाते हैं कि आप टैक्स पेयर्स के अगेंस्ट में केसेस लेते हो, लेकिन आपके जो ऑफिसर्स गलतियां करते हैं उनके अगेंस्ट में कोई भी केस आज तक नहीं हुआ है। तो नारायण जी अपनी पहचान हैं खुद, और बहुत उच्च कोटि के एडवोकेट्स और कंसल्टेंट हैं जिन्हें सुनने का आज हमें मौका मिला। मैं बहुत बहुत धन्यवाद देता हूं नारायण जी को कि हमेशा आगे भी अपने को समय देते रहे। धन्यवाद।
मैं ये समय एक बार और लेना चाहूंगा ये बताने के लिए कि हमारा 2 और 3 अक्टूबर को
हमारा एक टीपीएफ का राष्ट्रीय आयोजन हो रहा है और मैं सभी टीपीएफ के मेंबर से आग्रह करूंगा कि यदि उन्होंने रजिस्टर नहीं किया है तो शीघ्र अतिशीघ्र रजिस्टर करके जरूर इसमें ज्वाइन करें।
मैं आरडी काका को भी धन्यवाद देना चाहता हूं कि वो माने लीगल रिलीफ सोसाइटी की तरफ से उन्होंने चेयर किया है, चेयरमैन एज ए चेयरमैन। थैंक यू भाई।
बहुत बहुत धन्यवाद नारायण भाई जी। आपका हमारा सौभाग्य है कि आप जो है कि समय निकाल के हम लोगों को इतना बढ़िया समझाया किया, और आगे भी चाहते हैं कि आप इसी तरह हम लोगों को बताते रहें। सभी को एक बार धन्यवाद देते हुए आगे की कार्रवाई आलोक जी।
आज का हमने ये कार्यक्रम देखा। हम आदरणीय श्री जैन जी को बहुत बहुत साधुवाद देते हैं कि उन्होंने हमारा मार्गदर्शन किया और आगे भी करते रहे। भी जो उपस्थित हुए उन सभी को मेरा अभिवादन और धन्यवाद। इसी के साथ हम इस कार्यक्रम का अंत करते हैं।
ओम जय जिनेंद्र।
जय जिनेंद्र।
जय जिनेंद्र।
जय जिनेंद्र साहब।
जय जिनेंद्र। नारायण जी, जय जिनेंद्र भाई।
जय जिनेंद्र नारायण जी।
जय जिनेंद्र सभी को जय जिनेंद्र।
जय जिनेंद्र सुशील जी। जय जिनेंद्र। जय जिनेंद्र सुशील जी। थे भी आपने टाइम दियो थे भी पूरा एकदम। हाँ
पूरा समय।
धन्यवाद सुशील
जय जिनेंद्र साहब। जय जिनेंद्र।
जय जिनेंद्र साहब।
जय जिनेंद्र।